Hello and welcome back. We're now on video 5 of the 2020 Florida MPJE Bootcamp, and we've made it over to chapter 4 in the book. So as usual, we're going to start with our disclaimer and our warnings. I don't have any specific knowledge of the questions on the MPJE, and don't forget that NABP does not endorse this course, and I am not affiliated with NABP. And this material, the slides, video, and audio is copyrighted. It may not be recorded, reproduced, or stored without permission of Florida Pharmacy regulatory advisors. All right, so let's jump in to chapter 4. And I call this chapter Pharmacy Personnel and Pharmacy Practice. So what I tried to do was group together here rules that apply to individuals, and that's Roman numeral 1, as you'll see. So any rule that said the pharmacist must do this or the pharmacist must do that, where that kind of made sense. And then rules that apply to the pharmacy permit, and I started that on page 129 with rules that apply to any pharmacy permit, all pharmacy permits, and then we get into the specific rules that apply to specific types of pharmacy permits. It's not perfect, and part of that's because it's hard to figure out sometimes where to place these things. And you'll see I took some liberty to move things around. For instance, there's rules on labeling of prescriptions and things that it says, it doesn't say it's for community pharmacies, but really that's where that takes place, unless you're a limited community pharmacy in a hospital. So it's a little bit difficult, but I think I did a pretty good job trying to group these things together, and we'll go through that. I think what's important in this chapter is I tried to focus on the individuals and then the rules, and then really what takes place in practice, right? And a lot of these rules dictate what takes place in practice, which on the MPJE, that translates into a lot of these situational types of questions where you got to understand the rules, and I'm going to give you that information, but the questions are not going to be straight up, what is the rule? Some of them are going to be that way, but we talked in the very first video about situational questions, and this is where it can get very, very tricky. So study the rules, make sure you know the rules, but also make sure you know how to apply these rules to whatever question they give you. And I'll try and point out some of those things that I think can be tricky, or they can modify the situation somehow to try and trip you up, okay? So the first one is about rules applicable to pharmacists. And we get back to that definition on page 125 of the practice of pharmacy, which was in the statute that we talked about earlier. But this rule talks about things that only a pharmacist can do. And because that's part of the practice of pharmacy, only a pharmacist can do these things. And what the rule says, this is 27.1001, the functions that only a pharmacist can do, or an intern acting under the supervision of a pharmacist, and then it lists a whole bunch of items. So things like supervising the controlled substance inventory, receiving verbal prescriptions. So now we know technicians can't do that. Engaging in consultation with a practitioner about how to interpret a prescription. And that gets a little bit tricky because technicians can get clarifications on what a prescription says. We'll talk about that. But if it has to do with actually interpreting the prescription, that's a pharmacist's function. I did make a change in letter G, which says making the final check of a completed prescription, because again, this is where the rule's not written very clearly. I included everything listed in the rule because the top of that rule says these are things that a pharmacist and an intern can do. But the final check, actually that section of the rule starts out and it says only a pharmacist can do these things. So I think by including those words in there, what they're saying is an intern can't make that final check. So I did update in that letter G in the corrections document to indicate that that's the one function that an intern can't do even when they're being supervised by a pharmacist. The next rule in the bottom of page 125 talks about delegable and non-delegable duties. When you delegate a task to someone else, that's a delegable duty. And things you cannot delegate are things, again, that a pharmacist has to do. So if you read the 27.101, those are really non-delegable duties as well. But there's a separate rule that goes into a little bit more detail, and you'll see this in the study tip on 126. You have to read these two rules together, and they're not inconsistent, but it's just interesting that they're in two different rules. One's in 27.101 and one's in 27.420. So these are, because these are non-delegable duty rule, these are tasks and duties that only a pharmacist can do. And if you read the MPJE competency statements, it says, know the duties and tasks that a pharmacist can do, and other personnel. So this is a section that they're definitely going to ask questions on, and again, lots of those situational type questions. So you'll see on on 126, letter B, interpreting a prescription for therapeutic acceptability and appropriateness, right? So I could think of all kinds of questions they could give you related to that. That's a pharmacist function. A technician doesn't have that knowledge level that a pharmacist has to do that. Same thing for prospective drug review, monitoring prescription drug usage, letter D and E. Overriding a clinical alert, if your computer system gives an alert to a drug interaction, really only the pharmacist is the one that can override that. Now, so if you decide to delegate that to a technician, that's technically a violation, because only a pharmacist can make that determination of whether or not that's a significant alert that can be overridden. Transferring a prescription must be done by a pharmacist or an intern. You'll see patient counseling, obviously, as well, letter I. You'll see letter J. We'll get to nuclear pharmacy maybe towards the very end. Receiving therapy or blood product procedures in a nuclear pharmacy. The reason it says that is those are therapeutic drugs that are dispensed from a nuclear pharmacy. So because they're therapeutic, only a pharmacist can receive those orders in a nuclear pharmacy. Other prescriptions in a nuclear pharmacy that are diagnostic orders can actually be taken by a technician, verbal orders. So that's one exception where a technician can actually take a verbal order of a prescription is in a nuclear pharmacy, but it's a little tricky because it's only for diagnostic procedures. And a lot of nuclear pharmacy is diagnostic testing, but there are a lot of therapeutic products that are done for in nuclear pharmacy today as well. Okay, so then you go down to the next rule, and these are the non-delegable tasks, and this tells you what a pharmacy technician can do. And it's things that you would think, like data entry, labeling prescription, taking of files, and then it gets over to page 127, and it talks about initiating communication to confirm things like a patient's name, even the medication, the strength, the directions, the number of refills, the date. So if it's just seeking clarification on a prescription, on items like that, and it really doesn't involve professional judgment, a technician can do those things. And same things for if they're missing a date, the date it was prescribed, or the name, the prescriber's name is not clear, whether or not they want substitution or not, the quantity, they need to get the license number, DEA number. Those are not professional practice things that require a pharmacist. But I could very well see a question that's ambiguous and you have to make a determination. So the way I would approach that is just think about it. If it's something that requires the professional judgment of a pharmacist and fits within that definition of the practice of pharmacy, then probably a technician's not allowed to do that. And I think I put that in the study tip. Letter G is a little bit interesting to me on page 127. It does say a technician in Florida is allowed to accept authorization to refill an existing prescription that has no refills. So that could be really tricky, right? Because if it's you're adding refills to an existing prescription, then that's okay. But if there's any change made in the prescription to alter that prescription, then it's a new prescription. And only a new prescription verbally can only be taken by a pharmacist. But if nothing changes and you're simply adding refills to it, this sounds like a technician can do that if you're authorizing refills to it. Now, I do wonder in practice when you authorize refills to a prescription like that, if you're creating a new prescription number, is that now a new prescription? It sounds like no, if nothing's changed. Even if you give it a new number, we're not going to call that a new prescription because nothing's changed. So I do find that one a little bit interesting. Letter J talks about removing deteriorated pharmaceuticals to a quarantine area. I put a note there. I thought they were talking about, when I said deteriorated drugs, I thought they were probably just talking about nuclear pharmacies. But as I thought about it a little bit more, I said, maybe they're just talking about outdated drugs and removing outdated drugs from a regular pharmacy as well. So that's something that they can do. And that makes some sense. Okay. Let me go back a minute. Oops, we're jumping ahead here. All right, so when you delegate these duties to technicians, they still have to be supervised by a pharmacist. And if you read the rule on supervision of pharmacy technicians on the bottom of 127 and going over to 128, it says they define direct supervision, which means the pharmacist is readily and immediately available at all times these duties are being performed by a technician. But then if you read the definition of readily and immediately available, it says that either the pharmacist is on the premises, and then it says, or if not, technology using some type of two-way communication is available between the pharmacist and the technician. What is that trying to say? If you read that the use of technology on the page 128, it says you can use technology basically to supervise technicians. And I put in the study tip there on 128 is basically what that's saying is you can have remote supervision of pharmacy technicians as long as you got audio visual communications. That could allow things like technicians working from home to do order entry. Now obviously you got to meet HIPAA requirements for privacy if you do something like that, but this is kind of a fairly new thing that specifies remote supervision of pharmacy technicians, not at the same location as the pharmacist. Okay. So the next section is the pharmacy technician ratio rule, and that's rule 27.410. Florida, because they got to do things more complicated, has a bunch of different ratios. And I don't know why, but the rule still says that the ratio is 1-to-1 unless otherwise authorized under this rule. And guess what? It is otherwise authorized under this rule. So it's not 1-to-1. So I put that in the study tip because it says the next thing, letter 3B on page 128 says any pharmacy could have a 6-to-1 ratio as long as the technicians are not performing sterile compounding. So it doesn't make any sense to me whatsoever that it still says it's 1-to-1 in the rule. I would just ignore that because any pharmacy can now have a 6-to-1 ratio. However, if the technicians are involved in sterile compounding, then it goes down to a 3-to-1 ratio. So it's basically 6-to-1. If you're doing sterile compounding, then it's a 3-to-1 ratio, and that's 3 technicians per pharmacist that's working. I did make a correction to letter 3C and the study tip. Actually, to the study tip. And this was just a misinterpretation again when I was reading the rules. What it said was that the 3-to-1 ratio only applies to those technicians who perform in the sterile functions, and I thought that meant that a pharmacist could supervise those 3 technicians plus 3 additional technicians, but that's not what it meant. I read a little bit more detail on this, and you'll see this in the correction document. What it means is if you have technicians that are doing sterile compounding, they are subject to the 3-to-1 ratio. But if that sterile compounding is being done in a separate part of the pharmacy that's physically separate from the other part of the pharmacy, the other part of the pharmacy can have a 6-to-1 ratio if they have another pharmacist working there. So it's not adding 3 to the one pharmacist who's adding to the sterile compounding one, it's an additional pharmacist. They can have a 6-to-1 ratio, but only if it's a separate section of the pharmacy, physically separated from the sterile compounding area, which normally it would be because you think you're gonna have an IV room or something that does that. So just make sure you read the updated version of the study tip on page 128 in the updated document. Okay, and then finally, there's an 8-to-1 ratio if the pharmacy doesn't possess any drugs, it doesn't do any dispensing. So what kind of pharmacy would that be? That would be like a remote order entry pharmacy that's just doing remote entry for other pharmacies or for hospitals or something like that. Okay. Interns, it says that they have to be under the direct and immediate supervision of a pharmacist. And remember, they can really perform any function that a pharmacist can do, except for that final check, as we just corrected in the previous section. All right. So now we move to rules that appear to apply to all types of pharmacists and all types of pharmacy permits. And the first one is one that we alluded to earlier when we were talking about who has prescriptive authority. And I mentioned this in the other section where we're talking about prescriptive authority, because when this law was passed, it was considered, one of the first laws to give pharmacists prescriptive authority. So that's why I included it in the other chapter. But like I said, it's really not done much in Florida anymore. And but it is still in the law, and there's still rules on it. So they could ask this on the MPJE. What it says is there's categories of there's a formulary or category of drugs that can be prescribed. They don't even use a prescribed word, can be ordered by a pharmacist and then dispensed by that same pharmacy. And in the statute, it's pretty restrictive because obviously the physicians didn't like this, so they made the law very, very restrictive. So it's things that have been approved to move from prescription to OTC status. Well, if it's going to be OTC, you got the authority to order that. Big deal, right? But it does have things like anything with fluoride in it. Letter E, lindane for lice. That was one that was actually used in the beginning because that required a prescription. Topical anti-infectives, including ear and eye anti-infectives, things like that. So those are the broad categories that the law allows. And then there's a committee that has to get together and actually put the list of specific drugs that a pharmacist can order and dispense. Number 3 on page 130 lists when the law was passed, how the pharmacist has to label the drug. And it required letter, so anytime we have to deal with labeling, you got to know what the required elements are on the label. So I listed what was in the statute here for you. Again, look at your update document because unfortunately, that's what was in the statute, but the rule adds 2 more additional things. And again, this is just very poor rule writing and not being organized because they're in completely 2 different sections. But this is required by the statute. And when they wrote the rule, instead of repeating that information, when a pharmacist reads the rule on how to do this, it just says, oh, in addition to the stuff required in the statute, you also have to put the name of the drug and the quantity dispensed, which means you got to go back to the statute and look at the other lists. Why don't you just put it all in one list and make it a lot easier for pharmacists to understand? So I did that after I caught the issue, and I added the 2 things required in the rule, and that is name of the drug and quantity dispensed. So that is also required as part of the labeling. And there's a lot of things you can't do. It can't be injectable drugs. It can't be more than a 34-day supply. That's something that they could ask you. Nobody hardly does this in practice, but on the MPJE, they could ask you the labeling requirements. They could ask you what drugs can be ordered by a pharmacist. They could ask you how many days supply. You do have to create a prescription. You have to maintain a patient profile. And there's also a typo on page 131. You have to keep that profile. It says for 7 years. That was changed to 4 years on letter H on page 131. Again, that's in your update and correction document. I went ahead and listed the entire formulary of drugs for you. I would just kind of know the categories. but those are the drugs that are approved on page 131 and 132 for order by a pharmacist. Okay, a much more practical law, and one that's actually used, is administration of vaccines and epinephrine auto injectors. And most states have this. So the rules differ from state to state, and you got to focus on the specific Florida requirements. First of all, in order to provide vaccinations in a pharmacy, the pharmacist has to be certified. Interns as well can be certified to do this. And you're doing this under a protocol with a physician. I found it a little bit interesting in Florida. The protocol is between the physician and the pharmacist, not with the pharmacy. In a lot of states, it's with the pharmacy, and anybody who's certified who works at that pharmacy works under that protocol. Here, the protocol is with the individual pharmacist. So each pharmacist should have the written protocol with the physician. You can see the requirements for the certification training for this are on page 133. It's a 20-hour continuing education course. I didn't put the specifics of that training course in there. I just referred you to the rule. You might want to read that rule. I know it includes CPR training as part of the rule in case they ask that. But it is 20 hours of training to get certified to provide immunizations. And then to maintain your certification, it requires 3 hours of continuing education as part of your 30 hours. We talked about this earlier, to maintain your license every 2 years. One thing you got to look for in different states are the limitations to the types of vaccines that can be provided? Are there limitations on age restrictions? Because this does vary from state to state. Florida's done a pretty good job on one of those and not so good a job on the other ones, in my opinion, because they allow any immunization that's listed in the adult immunization schedule by the CDC as of the 2015 version. So pretty much anything that's listed in that immunization schedule, a pharmacist can provide. That's good. It's pretty broad. However, it's only for adults. So you can't do an immunization for someone under the age of 18. Okay. So that brings up an interesting question is, you're working under a protocol, and what happens if the protocol expires, or you get if the protocol expires, you can't provide any immunizations under that protocol. But somebody asked me this question one time. They said, if the protocol has expired, but yet a physician wrote an order to you to ask you to provide the immunization, can you then provide the immunization? And I think you can, because here's the trick to that. The protocol is only required when you want to administer immunizations to people that walk into your pharmacy. As long as you're following the protocol, you can do that. So if you have an order from a physician and you are certified, your certification is not expired, I think in that situation, you could still provide the immunization because you're not doing it under the protocol. And I guess the same thing would apply if they asked you to, by an order, you had a prescription order that said, please provide immunization to someone under the age of 18, then you probably could, because you're not doing it under the protocol. That one's a little bit trickier, I think, because it would depend on how it's worded in the statute. Another requirement is you have to have $200,000 of liability insurance to provide immunizations. That's something else they could ask you. I don't think I have it in the book, but Florida also has a program called the SHOTS program, which is an electronic record of immunizations for people. When you give immunizations, you do have to report that you gave that immunization to that patient to the Florida SHOTS program. Okay. The next rule on the bottom of 133 is continuous quality improvement, or CQI program. So this is a mandatory requirement that all pharmacies must have. You must have a continuous quality improvement program, or CQI program. And what you're doing here is you're looking for what they call quality related events. And that's inappropriate dispensing, misfilled prescriptions or administrations in a hospital, a medication error was a wrong drug, wrong strength, wrong dosage form, wrong patient, incorrect labeling, um, not identifying drug interactions, things that you do as part of your drug regimen review on the top of page 134. So every pharmacy has to have a CQI program, and you must have a policy and procedure manual that describes your CQI program. And you have to review all quality related events. So you're not only looking for errors that did happen, it's helpful that you look for near misses where you caught the error before it got dispensed. Okay. And you have to review these quality related events at least every 3 months. The information and what you're trying to do with this continuous quality improvement program is determine, okay, what caused this error or this near error, and try to prevent that error from happening again in the future. So the idea is to try and improve, to protect public safety and reduce the amount of medication errors we have by learning from the experience. So when you do that type of thing, you're actually looking at what went wrong. Was it a staffing problem? Was it an operational problem? Was it a procedure problem? Was it a communication problem? When you're doing those types of things, you're doing maybe a root cause analysis to find out what the problem was. When this law was passed, what was very important was you want to protect that type of information from discovery in a lawsuit, because think about it, if there's a medication error and somebody was injured, there might be a lawsuit pending, or maybe a lawsuit coming. But we don't want to discourage pharmacies from having these quality improvement programs. In fact, it's mandatory in Florida. So, but when you do that type of analysis, you're kind of doing all the work for the plaintiff's lawyer, the person who's going to sue the pharmacy, right? So you don't want to do that for them and give them access to that information. So what's really important is number 7 on 134. That information is confidential. It falls under what they call peer review or medical review committees. So that information is not available to someone that's suing the pharmacy or to anyone else. Okay. You're required to have a policy and procedure for that. You're also required to have policies and procedures for pharmacy technician training on the bottom of page 134. You have to have a manual that shows what your pharmacy technician program training consists of, and then there's a list on page 135 of all the mandatory elements of that training program. And you can't just have the training program and a policy and procedure. You actually have to do the training, right? And you'll see that at number 2 on page 135. You have to have documentation and sign that a technician has gone through that policy and procedure manual within 90 days of the technician being hired. Okay. And also the pharmacy has to maintain documentation that they've trained the pharmacist in number 3 on page 135. The prescription area has got to be available for inspection by the pharmacy, by the Board of Pharmacy on the bottom of page 135. They have some special rules on the top of 136 that during your first year of operation, they're going to inspect your pharmacy twice a year. And then if you passed your inspection for the current 3 years and there's no discipline, they're going to move to an every 2-year inspection cycle for your pharmacy. There's rules on page 136 about you have to have a sink with running water and enough space and a refrigeration, things like that. Fortunately, the board's moved away from a lot of those very specific rules. And in the old days, a lot of pharmacy boards had very, very specific requirements about how much space you had to have, how much square footage, how much counter space, what type of equipment you had to have. And so they've gotten away from a lot of those really proscriptive requirements, but some of it's still in here, and you can read that on page 136, including the library requirements, which is something they could ask you. You have to have a reference on current pharmacy compendium, which would be USPDI or facts and comparisons or something like that, a copy of the laws and rules, and you could have electronic access that would work as well. But it's always good to know the library requirements. That it is listed on the MPJE competency statement, so that's something you wouldn't want to miss. Okay. Turning over to 137, and this is labels and labeling of medicinal drugs. Remember, medicinal drugs are prescription drugs. So you got to know labeling requirements. And again, this is something that your computer does for you, but on the MPJE, you need to be able to list out what the required elements are on a prescription. And there's a couple of little tricky things in here that I just picked up on as I was going through the rules. So number one on page G1 on page 37 is label requirements for drugs dispensed to a patient. So this is outpatient dispensing. And it's got things you would expect: name and address of the pharmacy, the date dispensed, the serial number, which is the prescription number, name of the patient, or the animal, if it's for an animal, name of the, I'm sorry, name of the owner and the species of the animal, if it's an animal, name of the prescriber, name of the drug. Um, Interestingly, the strength and quantity dispense is not listed in the rule. I don't know if that was an oversight, but it's technically not required. Directions for use are required, and a beyond use date, which can't be more than um, one date. Well, sorry, 1 year from the date it was dispensed. Okay. I put a couple of notes in there. Like, I found that strength and quantity wasn't listed. I thought that was interesting. Telephone number of the pharmacy is not listed. These are things that normally show up on the label, but it wasn't listed on as the required elements on the prescription. Then if you turn over to page 138, we got label requirements for customized medication packages. First of all, you need to know what customized medication packages are. Customized medication packages are convenience packages where you're going to put, let's say, 8 a.m. meds and 5 p.m. meds and 8 p.m. meds in the same package. So you're putting different drugs in the same package for convenience packages. Very helpful for like nursing homes or assisted living facilities and so forth. When you're doing customized medication packages, and that's not considered FDA repackaging because it's for your own use, it's for your own patient. So it's considered a type of pre-packaging. So that is part of the practice of pharmacy. It's not manufacturing. These are the labeling requirements for those types of packages, the labels for those. Now, you may not have to have everything on the label if you're part of a closed system of distribution. That's another advantage of having a closed system of distribution. But if you're like PillPack Pharmacy, and you're not part of a closed system of distribution for a nursing home or assisted living facility, and you're just sending these to patients' homes, you would have to have all this information on the label. In a closed system of distribution where they know that someone, either a med tech or a nurse or someone is in the nursing home or assisted living, is going to help administer the drugs to the patients, they allow some of this information on the label to be in medication administration records in those institutions. But if it's a normal patient at their home, these are the required label requirements, which I find interesting. Now, this one does require the telephone number of the pharmacy. It's interesting, too, that a customized medication package has to have a prescription number for each of the prescription drugs in the package, and then a serial number, a prescription number for the customized medication package. So it almost has like 2 prescription numbers. The beyond use date in these packages is not 1 year. It can't be more than 60 days from the day that a customized medication package was packaged. So that's a difference that they definitely could ask you. Okay, I would know the differences in the labeling requirements for regular prescriptions and customized medication packages. And then you'll see later on, we'll talk about nursing homes have some specific ones as well. Okay. All right. Record keeping. This is a rule that says for all pharmacy permits. All right. All prescriptions have to be retained for 4 years from the date of last filling. We talked about this a couple of times during the controlled substance rules because it's stricter than the 2 years that DEA requires. But the trick here, it's 4 years from the date of the last filling and not from 4 years that the prescription was issued or originally filled. You can use electronic records, which everybody does. I think it's helpful to know that they do have rules about that. Your electronic records have to be backed up weekly. I'm guessing most pharmacies do that more often than that, but the rule is weekly. And your computer system has to have, this is letter 3C on page 139. Your computer system must have the capability of producing a daily hard copy printout of prescriptions with all the required information that's listed here. So this is really an old rule that came from the DEA, and Florida has adopted this not just for controlled substances, but also for all prescriptions. And the reason you know it's an old rule is because it references a CRT display. Okay, if anybody knows what a CRT display is, you get bonus points. So that's a cathode ray tube monitor. That's an old-fashioned prescription monitor, which they don't even make anymore. Okay, so that tells you how old this rule is. And here's my theory on why this rule exists. When computers first started showing up in a pharmacy, remember DEA always relied on physical prescriptions and hard copy records. And they wanted those things marked with the red C and filed separately so they could do their investigations. And when computers started being used to do electronic records, I honestly think there was this fear that pharmacies or people who worked in the pharmacy were going to have somehow, and this probably could have happened, manipulate the computer records and do drug diversion, right? And they won't be able to catch any drug diversion. So they created this rule that said that originally the rule said you had to actually print out a hard copy of every prescription you filled that day. And the DEA wanted a hard copy printed out because they figured, well, if I print it out, nobody can manipulate the records. We have a hard copy. That's ridiculous because you have to print out a hard copy with every prescription you filled with a prescription number, date dispensed, patient's name, practitioner's name, quantity dispensed, the initials of the dispensing pharmacist. You'd kill a lot of trees if you did that. So the rule was finally changed to that, okay, well, if you don't have to print out the daily hard copy, if you keep a log book and you have pharmacists sign it, that the information entered into the computer was correct. So what the rule now says is you have to have the capability of producing what this is called an audit trail. So it shows everything that was dispensed from your pharmacy through the computer, right? Every pharmacy has the capability of producing this hard copy, but you don't have to print out the hard copy anymore. What it says on the page 140, letter D, is if you choose to print out the hard copy, I don't think anybody does this in real life, you have to produce it within 72 hours of the drugs being dispensed. So you have to print it every day, let's say, and then you can go through a long weekend, and then you'd have to print it out. I don't think anybody actually does that. And then, if you do print out a hard copy, every pharmacist who filled prescriptions during that are listed on that hard copy has to sign that hard copy within 7 days. Here's what everybody does is letter E. Instead of printing this hard copy, this daily hard copy, instead, the pharmacist can sign a log book. And the log book is just saying that everything they entered into that computer was accurate. And again, you got to be able to produce an audit trail out of your computer within 48 hours. Doesn't make a lot of sense anymore, this hard copy thing, but make sure you know you have to be able to produce the hard copy within 48 hours. I'm sorry, you have to produce the audit trail upon receipt within 48 hours. If somebody from the Department of Health asks for it, an inspector. If you're creating hard copies, which nobody does, it's got to be produced. It's called the daily hard copy. You're supposed to do it every day, but they give you up to 72 hours to do it in case you don't do it over the weekend or long weekend. So it's a little bit confusing, I know, but make sure you read through that section separately, carefully. Okay. And again, this audit trail is produced upon request from the Florida Department of Health, an inspector, let's say, within 48 hours. And it lists all the prescriptions you dispense in your pharmacy. Remember back to the DEA rule we talked about, if law enforcement asked for a list of controlled substance prescriptions, you got 72 hours to produce that. It doesn't make sense. One's 48 hours, one's 72 hours. It depends on who's asking for the information. There's two different rules. They do the exact same thing, but they have different time requirements. All right. Centralized prescription filling and dispensing. This is where a pharmacy decides to outsource the dispensing of their prescriptions to another pharmacy. That pharmacy fills the prescriptions for that pharmacy, sends them back to the originating pharmacy, and then they're handed to the patient. The idea was to relieve the pharmacist at the pharmacy where the patient comes to pick up the prescription, to having to deal mainly with refills. It works best with refills, although the rule doesn't restrict it just to refills. And the idea was we send all the prescriptions that have to be refilled where normally where the patient's not going to pick it up till the next day, to another pharmacy that's highly automated, and those are shipped out to the pharmacies. It works best with a group of pharmacies or a chain of pharmacies, and they're shipped out to all the individual stores. So it relieves the individual pharmacists in the store level from having to deal with a lot of refills. They're just dealing with new prescriptions and that type of thing. So Florida allows this. You have to have a policy and procedure manual. Make sure you know what who the originating pharmacy is, who the dispensing pharmacy is. Again, labeling requirements. It requires, the prescription is labeled with the name of the pharmacy that the patient's going to pick it up from. But the central fill pharmacy has to be indicated somewhere on that label. Just in case there's an error, the Board of Pharmacy will know who actually filled the prescription and who made the error, so they can discipline that pharmacy and that pharmacist maybe who made the error. But you don't want to, it doesn't require the central fills pharmacy's name put on the label, because having two names on the label could be confusing. But what it says is the central fill pharmacy has to be identified on the label by some type of code, maybe their license number or their DEA number or some type of code. And again, that's just to create an audit trail that the Board of Pharmacy could go back to in case there was an error in the centralized dispensing. Okay. The Board of Pharmacy does allow a central fill pharmacy actually to ship the drugs directly to the patient if they are non-controlled substances. The concept of central fill was originally that the central fill pharmacy, because they're labeling it for that original pharmacy where it came from, to send it back to that pharmacy and they can pick it up there. But if the patient's going to use a delivery service, it doesn't make sense to have it sent back there and then have it shipped to the patient. So they do allow the central fill pharmacy to ship directly to the patient, but only for non-controlled substances, because the DEA rules for central fill pharmacies do not allow central fill pharmacies to send it directly to the patient. DEA created a special registration for central fill pharmacies that only allows them to fill controlled substance prescriptions and send them to the originating pharmacy. All right. Drug therapy management on page 142. This rule allows pharmacists to perform things like monitoring the patient's drug therapy and ordering laboratory tests and interpreting those laboratory tests. And I talked about this earlier because remember, a consultant pharmacist and a doctor of pharmacy could do this under those rules, but that was limited to nursing home patients only. So this expanded it to any type of pharmacy permit, but one of the things it required was that the pharmacy must have a transferable patient care record that has a prescriber care plan and has orders from the physician for each patient. And I'm not sure what that means exactly, but it seems like it kind of limited the usefulness of the drug therapy management rules. And it also requires the pharmacy have a separate area that's distinct from the dispensing area where you can perform drug therapy management. So this was a good first step, I think, to expand the practice of pharmacy within Florida. I'm happy to let you know that that the legislature in Florida recently passed a more comprehensive collaborative practice law that's currently being implemented by the Board of Pharmacy. It won't be on your MPJE because even though the law has passed, the Board of Pharmacy has not developed rules for that, but it's going to be something I'm going to have to add to the book next year. But this one here does currently exist, so make sure you read through this drug therapy management rule. And there are some limitations on that because of the type of transferable patient care record. But it's a good thing for pharmacists. It expanded the ability to do order laboratory tests beyond just nursing homes, which was the first rule that passed. These things happen in stages, right? First pharmacists were allowed to order laboratory tests, but only for nursing home patients, and it's only consultant pharmacists. And then they got it changed to add PharmDs are allowed to do it, but still only for nursing home patients. And then we got the drug therapy management rule passed, and that expanded the ability to do it to all pharmacists and not just for nursing home patients. But there was this limitation about this transferable patient record and having a separate area in the pharmacy to do this. And I think the next stage of this was the new law that passed for collaborative practice, which is a little bit broader. So these things take time, they take many years to pass, but we're eventually moving in the right direction. Okay, let's talk about compounding. You're going to get questions on compounding, and you're going to get questions about sterile compounding in 797. I don't go into a lot of detail about 797. I'll just mention that briefly because it's just really beyond the scope of a review book. But let's just talk about compounding in general. It's important to know the definition of compounding and what Florida considers legal and part of the practice of pharmacy of compounding, and that's not manufacturing. And so reading the definition of compounding on page 143, it recognizes preparing and compounding drugs based on a prescription and an anticipation of prescriptions based on routine, regularly observed patterns. And even FDA recognizes, even FDA says, you know, if a pharmacy receives a lot of, they're next to a dermatologist's office and they're going to receive a lot of prescriptions for a certain formulation of a dermatological product, they can prepare it in advance. That's called anticipatory compounding. If they can show that, you know, every day we get 5 or 6 or 7 prescriptions for this particular formula because that dermatologist knows we know how to make it. Even FDA says that's okay. So I think that one's consistent. When products are not commercially available, can a pharmacist compound it? Well, the Florida statute says that, yeah, if you have a prescription for a product that's not commercially available, you can do it. So again, if it's patient specific, that's probably okay. Normally you cannot compound commercially available products, and FDA has said that. But what the Florida law says is that you can compound a commercially available product from bulk when the prescribing practitioner has requested you to do it and you do it on a prescription basis. So that's a little bit different. And I'm not sure FDA would agree with that, but I think because you're taking the exam for Florida, you want to go with what Florida has said. The big key to me, I think, is number 2 on the bottom of 143. When you prepare drugs or compound drugs and you transfer them to other pharmacies or other practitioners for the purposes of that entity dispensing or distributing them, that's not compounding. That's the problem that NECC ran into, right? They were preparing large quantities of these sterile products and they were selling them to clinics who were then reselling them or distributing them to other locations, right? They're also administering them in the office, and that's office use compounding. So there's a little bit difference between office use compounding, but clearly if you're compounding a product and you are sending it to other pharmacies or other physicians, and they're gonna redispense it for outpatient use or redistribute it, that's not compounding. So you can't compound a product to someone else and have them resell the product. But the tricky thing is you can do compounding if it's going to be used for office use and it's going to be administered in the office. And again, I don't think FDA would agree with this. And a lot of states have this. Texas, where I am at, has it as well. But for MPJE purposes, normally when the laws conflict, you got to follow the federal law. But in this case, I think you make an exception. because I don't think the laws actually conflict. I think it's a matter of the federal law is not clear on this, and FDA is kind of ambiguous on this. So I think you do need to read the office use compounding section on page 144 and make sure you know when you can prepare a product. It's not patient specific, right? And it's going to an office and it's going to be used in that office for administration. Don't fill a prescription for office use. You only want to fill a prescription's got to be for a patient or for an animal, not for a particular, not for use in the office. So no prescription for office use, but you can do office use compounding based on an order from a physician. Okay. Now remember, when we talk about this office use compounding, we're only talking about non-sterile products because if you're doing sterile products and they're non-patient specific, even if they're going to be used in an office, what would you have to be? You'd have to be an outsourcing facility. Remember, under the federal law that was passed, and Florida licenses those facilities separately because that's to prevent the NECC situation where they're shipping these sterile products to clinics and they're being injected into patients. So for sterile products, you can't do office use compounding, which is non-patient specific, unless you are an outsourcing facility. Okay, so if you are doing office use compounding, you're going to create a batch of something. So there are special record keeping requirements on page 145. You have to keep a record of a control number of each batch of a compounded product, including the manufacturer's lot number. This is in case we have a recall or something like that requires, you need to know, which batch was made from which particular lot number. Okay, and that brings us to page 146, and these are the standards of practice for compounding sterile products. This is basically Florida's version of USP 797, but it's a little bit broader than that. So what this section does, and they conveniently labeled and numbered this rule as 64B 1627.797 to kind of remind you what it is. So it's mainly related to chapter 797 and USP. So the rule basically adopts USP 797 for all sterile products compounding in Florida with some variances or exceptions that they wanted to clarify that are a little bit different. And I got the clarifications and variances listed for you on page 146 and over 147. I'm not sure how important that is, but since it is different than what USP has, I did include that for you. A couple things to note here. First of all, the Board of Pharmacy adopted, I think it's a 2013 or 14, I can't remember what the date is on it, but the older version of USP 797. Realize there's a new version of USP 797 that was supposed to come out in 2020. And I've got this on pages 148 and 149. I wanted to at least include a summary of that because at the time I was publishing the book, this was expected to become finalized, and yet there were some appeals to it. Some people weren't happy with the changes, and that USP accepted those appeals. So the new version of USP 797 has been delayed, and they're going to redo it. So you can pretty much not worry about the major changes. I tried to include a summary of the major changes for you on page 148 and 149 because they were not adopted by USP. And honestly, even if they were, they're not part of the Florida law, so it should not be on the Florida exam anyway. So you're gonna have to restudy the old USP 797, and I've got a study tip there that that is a competency statement and has been adopted by Florida. So you need to study USP 797. Obviously, if you're familiar with it, if you just graduated from school and you've gone through sterile product certification, you probably know it pretty well. If you're coming from a hospital pharmacy practice in another state, you probably know it well, or home infusion type of practice. But if you're a community pharmacist and you've never done sterile compounding before, you really need to read some summaries of USP 797, because there will be questions on 797. Um, it's just beyond the scope of something that we have time to go through in this review course. I do think it's important to know which chapters of USP Florida actually adopted, because they could ask you that. So they've adopted 797 on sterile compounding. They've also adopted chapter 71 on sterility testing. This is on page 146. Chapter 85 on bacterial endotoxins tests, and chapter 731 on loss on drying. Interestingly, they didn't adopt 795, which is non-sterile compounding. So that's not been adopted by Florida. So again, I would recommend you get a summary of USP 797 if you're not familiar with the requirements. I added a slide here for you, because one of the things that could be a very easy question they could ask you is, what are the expiration dating? And in the current version of USP 797, they divide the products into categories of either immediate use products that are going to be used immediately, low risk, um, and then low risk with a 12-hour beyond use date, medium risk, and high risk. In the new version, they're going to kind of get rid of some of those categories, but again, that's been postponed. But you should know these expiration dating. Well, the expiration. What's the expiration for a refrigerated product that's a medium risk product, right? And that's 9 days. So this is something I think you need to jot down, copy this down. I don't have it in the book. I'm definitely going to add it. I think probably next year if USP hasn't changed. But that's something you want to be familiar with. And you also need to be familiar with, what is a low risk product? What is a medium risk product? What is a high risk product? Those types of things. But I don't have time to go into all the details of USP 797. Okay. Before we jump into page, before we leave the compounding section, let me just turn over to 150 a moment and talk about, there's a rule here that the Florida Board of Pharmacy adopted about lyophilized products. It's fairly detailed and fairly technical. I don't think, and it's fairly new, so you might get a question on it. Hopefully it won't count towards your score. I have a personal opinion about this, but Florida found out that there were pharmacies that were basically creating a lyophilized product as part of their compounding practice. And in my opinion, I think this probably falls under manufacturing and something that FDA would not allow. But I think the Board of Pharmacy felt like FDA is not enforcing this. We need to protect the public. So if a pharmacy is going to do this, and they know there's pharmacies in Florida doing this, we're going to have some very strict requirements. And this is where they cite some of those other chapters, like chapter 71. So I put the rule here in here for you. And again, it's kind of technical, so I don't have time to go through it. It's a very unique rule that Florida has adopted that I've not seen in any other state. So that's for you on page 150 and 151. Okay. Oh, before we do that, one other thing on back here on USP chapter 800 on page 152 and 153. This one I included because it's listed in the MPJE competency statements. It specifically says USP chapter 800, and this has to do with hazardous drugs. Florida has not adopted USP 800. So I would like to tell you that you're not likely to see a question on it, but there's this one little technicality. Number one, it's in the MPJE competency statement. And technically, any USP chapter under number 1000 is enforceable by the FDA, even though they really don't enforce a lot of these things. They rely on the states to do it. I would like to think that until a state adopts the rule, they wouldn't ask any questions about it. But just like the deceased practitioner, I would like to think that Florida and other states that don't have a rule on deceased practitioners would not have a question on it. And that doesn't seem to be the case. So maybe the people who are choosing the questions to put on the Florida exam have decided, oh, well, USP chapter 800, everyone has to follow that because it's under the number 1,000. Let's ask questions about it. I would hope not. I mean, I would argue that it's not the rule in Florida. It's not been adopted by the Florida Board of Pharmacy yet. So it's really not a fair question. So it just concerns me. So I felt like I needed to put a summary of USP Chapter 800 on hazardous materials in the review guide. So I did do that. Hopefully it's not on there, but I do have a summary on page 152, 153, 154, and even over to 155. Okay. Right, let's leave compounding. On the bottom of 155, we get to other rules that I found that were applicable to all permits. And one talked about transfer of drugs and a change of ownership. So when you're going to transfer drugs to a new pharmacy because there's been a change of ownership, you got to take an inventory of all the controlled substances. And because there's a change of ownership and a new DEA number, remember, you could temporarily use the old owner's DEA under that power of attorney, but once there's a new DEA number, there's actually got to be a transfer of those Schedule II drugs using a 222 form. All right, the next rule is outdated pharmaceuticals, and it's Rule 64B 1628.110 on page 156. And what this says is that if you've, in your pharmacy, you have to remove all drugs that are deteriorated, misbranded, or adulterated, basically out, expired drugs out of your pharmacy. You can't have them in your pharmacy. I put on the slide there, how often do you have to do this? Is it every 4 months? And the reason I put that on there is because I kept getting that question from people, and apparently there's practice questions that are out there, and they have that listed as the correct answer, that you must check your shelves for outdated pharmaceuticals every 4 months. And I kept looking for where it said that in the rule, and I couldn't find it. And what I found was, I went back into a little history, is the language that says you have to do that every 4 months was removed out of the rule in April 2019. So if you see a practice question on that, it's based on the rule that existed prior to April 2019. So I don't think the correct answer is you have to do it every 4 months. You just can't have any outdated pharmaceuticals in your pharmacy period. So how often you choose to do it is up to you. But the rule is you should not have outdated pharmaceuticals on your shelves. I guess if there's no other choice available, I would choose every 4 months, but I'm telling you, that's not the correct legal answer anymore. Okay. A couple other miscellaneous rules is you can't advertise. We talked about you can advertise drugs, and if you're only doing the price of the drug and the name of the drug and not talking about therapeutic effectiveness. But Florida has an additional restriction on advertising, is you cannot advertise or promote drugs that are controlled substances. All right. I'm going to skip through the information disclosure and go down to number 5, which is permit single entity, single location rule. So what this says is that only one entity at a location can own a pharmacy permit. So you can't have 2 different corporations or 2 individuals that own a permit or have different permits at the same location. So every location, a location in Florida can have more than 1 permit. We talked about that. If they're doing a hospital can have a limited community permit, that's okay. But those permits have to be owned by the same entity. You can't have 2 different entities having different permits at the same location. There's a rule on page 157 that basically says you can't have rebates in your pharmacy, which is this is basically an anti-kickback law where you can't receive a payment or commission or paying a physician for every prescription that they send you. That's a kickback prohibition. And we talked about you have to have human trafficking continuing education by 2021. As part of that law that passed that, it also requires that you have a sign in your pharmacy that tells people if they need help and they're subject to human trafficking. I know someone there's some 1-800 or helplines that they can call, and the language for that is listed in the book for you there on page 157. Okay, I think we'll stop there and we'll pick up again with community pharmacies in the next video. And thank you for joining, and I will see you with the next video.